I came out of anesthesia at 11:17 in the morning, which I know because the recovery room clock was directly in my line of sight, and I have an auditor's habit of noting times. The surgery had gone well, a hip replacement, 6 weeks of recovery ahead, nothing life-threatening but serious enough that my mind was still foggy and my body felt distant and strange in the specific way that major surgery produces. My daughter Maya was sitting beside my bed when I woke up, and the expression on her face was not the relieved, careful expression of someone waiting for a parent to recover from surgery. It was something else, something she was working very hard to contain, and I knew before she said a word that something had happened. She took my hand. She said, "Mom, I need to tell you something, and I need you to stay calm." I told her to tell me. She told me. They had come while I was in the operating room, an HOA contracted demolition crew with a court order, a backhoe, and the efficient disregard of people doing a job they had been paid to complete. My grandfather's barn, the one he built in 1944, the one where my father was born during a February snowstorm because the roads were impassable, and my grandmother had no other choice, the one that still had my grandfather's handwriting on a board inside the hayloft where he had measured his eldest son's height every birthday from 1945 to 1962, that barn was gone, not damaged, not partially demolished, gone. Leveled to a concrete foundation and a pile of lumber that had been loaded onto a truck and taken away before noon. I lay in that recovery room with my daughter holding my hand, and I felt something I had not felt since my father's funeral, a grief that was physical, that had weight and temperature, that pressed against my sternum from the inside. I let it be there for exactly the time it needed. Then I asked Maya to bring me my phone, my reading glasses, and the contact information for my attorney, because while I had been under anesthesia, someone had made the most consequential mistake of their professional lives, and I was going to make sure they understood that completely before I was discharged from this hospital. My name is Alina Voss. I am 67 years old, a retired financial auditor, recently recovered from a hip replacement surgery that I scheduled with considerably more precision than the Clearwater Hills HOA apparently applied to their legal strategy. I live on 11 acres in rural Tennessee land that my grandfather purchased in 1938, that my father farmed for 40 years, and that came to me through my parents' estate approximately 15 years ago. I want to tell you about the barn before I tell you about its demolition, because the telling of what was destroyed matters to the full weight of what came after. My grandfather, Wilhelm Voss, built the barn in 1944. He was 38 years old, had been farming this land for 6 years, and needed a proper structure to replace the agging shed that had served inadequately as animal shelter and equipment storage since he purchased the property. He built it himself, with help from 2 neighboring farmers who traded labor in the way that rural communities managed large projects before the era of specialized contractors. You helped your neighbor build his barn, and your neighbor helped you with yours, and the cost was sweat and time, and the shared competence of people who built things because building things was what you did. The barn was 60 feet long and 36 feet wide, with a gambrel roof that gave it the classic silhouette that people associate with American agricultural heritage, and that was specifically designed, in the vernacular architecture of the period, to maximize hayloft storage capacity while minimizing the structural load on the side walls. It was built from lumber milled at a local sawmill that no longer exists, using joinery techniques, wooden pegs, hand-cut mortise and tenon joints that reflect a pre-industrial construction tradition that had essentially disappeared from new construction by the 1950s. Inside the hayloft, on a structural board on the eastern wall, my grandfather had recorded his eldest son's height every year from 1945 to 1962, a practice that began when my father was 4 years old and continued through his 18th year, each mark accompanied by the date in my grandfather's precise Germanic handwriting. My father had shown these marks to me when I was a child, telling me what he had been doing on each of those measurement days, weaving a family history out of marks on a board that spanned 17 years. My father was born in that barn on a February night in 1941, during a snowstorm that made the roads impassable and left my grandmother no other option. He told this story with a wry humor that increased with each retelling. He claimed that being born in a barn had given him an immunity to cold weather and an affinity for large animals that served him well through 40 years of farming. He died in 2009 in the farmhouse 100 yards from the barn, and the barn was standing when we buried him, and I had believed it would be standing long after me. I had been wrong about that. The CLEARWATR development and how it arrived. Clearwater Hills is a residential development of approximately 140 homes built on land adjacent to and partly carved from the broader agricultural area surrounding my grandfather's original purchase. The development was built out through the 1990s and early 2000s, and its arrival in the rural landscape that my family had occupied for more than 60 years was, I want to say honestly, something I had mixed feelings about from the beginning. Not hostile feelings, not the reflexive opposition to change that sometimes characterizes longtime rural residents' responses to development, but an awareness that the arrival of 140 households and their associated expectations and preferences would inevitably change the character of a place that had, for most of my family's tenure on it, been defined by the rhythms of agricultural life rather than residential ones. The development's founders had been thoughtful, in some respects, about this transition. The entry-level marketing for Clearwater Hills had specifically emphasized the historic rural character of the surrounding landscape, had used photographs of working farms, including, I eventually discovered, photographs that included my grandfather's barn in the background, to establish the aesthetic context for the development, and had written into the HOA's initial governance documents language about preserving the agricultural heritage character of the community's setting. This language would later become relevant in a way I don't think the developers had anticipated when they wrote it. My direct relationship with the Clearwater Hills HOA had been, for most of the development's existence, minimal. I was not a member, my property was not part of the development, and the HOA had no formal authority over my land. Our interactions had been primarily practical, occasional discussions about drainage, once a conversation about a fence line near where the development's southern boundary met my property's northern edge, the kind of neighborly contact that is normal and unremarkable between adjacent properties. The barn dispute began approximately 2 years before the demolition morning, and its origins were, as these things often are, more incremental and more complicated than the dramatic endpoint might suggest. The dispute history. The barn sat approximately 40 feet from my property's northern boundary, which is also the southern boundary of the Clearwater Hills development's main entrance area. The development's entrance, including its stone entry pillars, its landscaped median, and its access road, is situated such that anyone approaching from the county highway has a clear, direct view of my barn from the moment they turn into the development until they pass the entry pillars and the road curves slightly to the left. For most of the development's existence, this view was apparently considered a feature rather than a problem. The marketing photographs I mentioned, several of which I have printed and retained in my files because they became legally relevant, include at least 4 images where the barn is clearly visible in the background behind the entrance landscaping, providing exactly the kind of historic rural character, aesthetic, that the development's marketing had promised. The problem arose when the HOA elected a new president approximately 3 years before the demolition. Her name was Constance Albright, and she had moved to Clearwater Hills from a suburban setting in another state and had, by most accounts from people who knew her, a very specific aesthetic vision for what a residential community should look like, a vision that did not include an agricultural building visible from the community entrance. Constance raised the barn issue at her first HOA board meeting after being elected, characterizing it as an eyesore affecting property values and asking the board to explore options. She was told by the HOA's management company that my barn was on my private property and outside the HOA's jurisdiction. Constance did not accept this as a final answer. Over the following several months, she engaged the HOA's retained attorney, a man named Stephen Garland, who practiced HOA law in the county seat, to explore whether any county code provisions applied to my barn's condition that might give a public authority leverage to require changes. She commissioned a report from a structural engineer using HOA funds, characterizing the barn's condition as potentially hazardous. She contacted the county building department and the county code enforcement office, filing formal complaints about the barn's structural condition and requesting inspection. I want to be honest about the barn's condition at this point in the story, because accuracy here matters. The barn was old. 80 years of Tennessee weather had done what 80 years of weather does to wooden structures. The roof had been replaced twice in my ownership, most recently approximately 8 years before the demolition, and was in reasonable condition. Several of the original siding boards on the east face had been replaced at various times with boards that didn't perfectly match the originals. The structure had settled over decades in the way that all old agricultural buildings settle, which produced some visible evidence of movement, a slight lean in the south wall, some gapping in the siding joints that was not structural compromise, but that looked, to an eye unfamiliar with agricultural buildings, like deterioration. The structural engineer's report, which I obtained a copy of through the county code enforcement process, concluded that the barn showed evidence of deferred maintenance and structural settling, and recommended evaluation by a qualified structural engineer to assess continued habitability. It did not conclude that the structure was unsafe. It did not conclude that it should be condemned or demolished. It noted conditions consistent with an 80-year-old wooden agricultural building that had been maintained but not renovated to modern standards. The County Code Enforcement Office received Constance's complaint, reviewed the structural engineer's report, and sent me a letter requesting that I engage my own engineer to assess the barn's condition and provide documentation that the structure was not a safety hazard. I engaged an engineer. His assessment concluded that the barn was structurally sound for its existing use as agricultural storage, that the settled elements were stable and had not progressed in any measurable way in recent history, and that no immediate remediation was required. I provided this assessment to the county. I thought the matter was resolved. It was not resolved. What happened next is the element of this story that I find most difficult to describe with equanimity, because it involves a court order that was obtained through a process I was not properly notified of, a procedural failure that became central to the subsequent legal proceedings. Constance, working with Stephen Garland, filed a nuisance action in county civil court, not against me personally, which would have required proper service of process and an opportunity for me to respond, but against the property itself, using a procedure that exists in Tennessee law for addressing dangerous and dilapidated structures on properties where the owner may be unknown or unresponsive. This procedure, which was designed for abandoned properties whose owners cannot be located, requires a specific notice protocol that includes posting on the property and publication in a local newspaper. The notice was posted on my property, on a fence post at my property's road entrance, not at the barn itself or at my house, during a period when I was traveling for a family matter and checking the property every other week rather than daily. I did not see the posted notice. The newspaper publication was in a legal notices section of a local weekly newspaper that I did not subscribe to and did not regularly read. Whether the notice procedure was legally adequate is something my attorney subsequently contested vigorously. My position and my attorney's position, and ultimately the court's position, was that it was not adequate because I was not an absentee owner with an unknown address. I was a resident of the property whose contact information was in the county tax records, in the county court's own property records, and readily available to anyone who made a basic inquiry. The procedure used was designed for situations where the owner genuinely cannot be located, not for situations where the owner's identity and contact information are a matter of public record. What I did not know, during the period the notice was technically running, was that Stephen Garland had filed a motion requesting a default order, an order demolishing the barn based on the respondent's failure to appear, and that a county judge had granted it. I did not know about the court order. I did not know about the motion. I did not know until Maya told me in the hospital recovery room on the morning of my hip replacement surgery that a court order existed and that a demolition crew was acting on it. The surgery had been scheduled for 6 weeks. The demolition, I later determined, had been scheduled for the same week as the surgery by someone who had access to community information about my schedule. Constance Albright had told at least 2 neighbors. I was informed afterward that she had made sure the demolition would happen while Elena is in the hospital. Whether this timing was deliberately coordinated or coincidental, I cannot prove with absolute certainty. The fact that Constance made the statement she apparently made suggests the former. What I can prove with complete certainty is that the demolition crew arrived on the morning of my surgery, acting on a court order I had not been properly notified of, and that my grandfather's barn was gone before I woke up from anesthesia. Maya and the hours in the hospital. I want to tell you about my daughter Maya, because she matters to this story in ways that go beyond being the person who told me what happened. Maya is 38 years old, a litigation attorney who practices in Nashville. She did not specialize in property law, but she understands legal process with the clarity that litigation practice develops over time, and her reaction to what happened at the barn, which she had driven to the property to investigate the moment she received a call from a neighbor about the demolition crew, was faster and more focused than my own reaction could have been in the hours immediately after surgery. By the time I was conscious and she was telling me what had happened, Maya had already done 3 things. She had photographed the demolished site in detail. She had obtained, from the county clerk's office, using her attorney credentials, a copy of the court order and the underlying case file. And she had called a property and civil litigation attorney named Robert Beaumont, who practiced in the region, and who she had identified as having significant experience with unlawful demolition and property rights matters. When I asked for my phone and my attorney's contact information, Maya told me she had already made the call. Robert Beaumont arrived at the hospital that afternoon. He sat in a chair beside my bed while I lay in a recovery room that smelled of antiseptic and plastic, and he told me what he had found in the case file and what he thought the legal landscape looked like. The illegal procedure issue was serious and clearly documented. The notice protocol used, property posting and newspaper publication, was the procedure for cases where the property owner's identity or address was genuinely unknown. The county tax records showed my name and address. The county property records showed my name and address. A 5-minute inquiry at any county office would have produced my contact information. The application of the absent owner procedure to a known, present owner was a procedural violation that, in Robert's assessment, rendered the court order void. Additionally, the structural engineer's report that had been the basis for the nuisance action had not concluded that the barn was dangerous. It had recommended further evaluation. The county code enforcement officer's own response to Constance's complaint had asked for my engineer's assessment, which I had provided and which had concluded the barn was structurally sound. The motion for default order had been filed and granted without the court having access to my engineer's counter-assessment. Robert said, "Elena, I want to give you the honest assessment. The procedural violations are serious, and I believe we can get the court order vacated. But the barn is gone. Vacating the order doesn't rebuild it. The legal question is what remedies are available for the demolition of your property pursuant to a void court order." I asked him what remedies were available. He said the remedies include civil claims against the HOA for the value of the structure, civil claims against Stephen Garland personally for the procedural violations in obtaining the order, and potentially criminal referrals depending on what the full investigation reveals. But I want you to understand something about the financial remedy question. The barn's value as a demolished agricultural building is one number. Its value as a historic structure with documented family history is a different number, and the punitive damages exposure for demolishing property pursuant to a void court order, particularly when there is evidence that the timing was deliberate, is a third number. I want to do a full assessment before I tell you what the realistic recovery looks like. I said, Robert, I want to ask you one question that is not about financial recovery. He said, ask. I said, is there anything I can do to prevent Constance Albright from ever doing something like this to anyone again? He looked at me for a moment, then he said, that depends on what we find when we pull all the threads, but yes, I think there may be. I told him to start pulling. Robert Baumont's investigation. Robert spent 3 weeks conducting the most thorough investigation of a property matter that I had witnessed since my own years as a financial auditor, and I mean this as genuine professional respect, because the investigation was methodical, exhaustive, and produced findings that neither of us had fully anticipated when he began. The first finding was the procedural violation documentation. Robert pulled the full case file from the county clerk, obtained all communications between Stephen Garland and the County Code Enforcement Office, and engaged a procedural law expert to provide a formal opinion on whether the notice procedure used was legally adequate given the circumstances. The opinion was unambiguous. It was not. The procedure applied was for genuinely unknown owners, not for owners whose information was in the public record. The second finding was the documentation of Constance's apparent deliberate timing. Robert located and interviewed 3 Clearwater Hills residents who had heard Constance's statement about scheduling the demolition while I was in the hospital. 2 of them were willing to provide signed statements. The third was uncomfortable doing so formally, but confirmed the statement's content informally and agreed to be listed as a potential witness if formal proceedings required it. The third finding, and this was the one Robert described to me with the specific tone that told me it was significant, involved the title to the land under the Clearwater Hills entrance gate. Robert had been reviewing the county property records as part of the general investigation into my property's relationship with the Clearwater Hills development, and he had, in doing so, pulled the chain of title for all adjacent parcels. What he found for the parcel containing the development's main entrance, the stone pillars, the landscaped median, the access road from the county highway, was a chain of title with a specific gap. The parcel had been assembled by the original developer, Blue Ridge Construction, from several smaller parcels in the early 1990s. One of those smaller parcels, a narrow strip running along the road frontage, had been purchased from a prior owner through a transaction that, when Robert examined the deed language closely, had not been properly executed. Specifically, one of the signatures on the deed was from a person who had died 18 months before the deed's execution date, a discrepancy that had apparently gone unnoticed through the subsequent transactions and title searches. The deed with the dead signatory was void, which meant that the strip of land it purported to convey had never actually transferred, which meant that the strip remained in the prior owner's estate, an estate that had been wound up improperly, with the strip not accounted for in the estate's distribution because it had appeared, due to the void deed, to have already been conveyed. Robert traced the prior owner's estate distribution through the probate records and found that the residual estate, the assets that hadn't been specifically accounted for, had passed to the sole heir, whose name he found in the probate file. Then he cross-referenced that heir's name against county property records to find their current status. The heir had died approximately 20 years ago, leaving her estate to her only living relative. Robert called me on a Thursday evening and said, "Elena, I need to ask you something. Did you have any relatives in the county going back 2 or 3 generations?" I said yes, my grandfather's family. He said specifically, "Did Wilhelm Voss have any siblings?" I said he had one sister, Gertrude. She had never married, had lived in the county her entire life, and had died in the early 2000s. Robert was quiet for a moment. Then he said, "Elena, Gertrude Voss is in the probate records as the heir to the estate of the prior owner of the strip of land under the Clearwater Hills entrance. And the residual estate documentation shows that the strip, which appeared to have been conveyed, but had not been properly conveyed due to the void deed, was inherited by Gertrude as part of the estate residue. I said, and Gertrude died without a will. He said, without a will, leaving no spouse and no children, which means her estate, including any property interests she held, passed by intestate succession to her closest living relatives. I said, which was my father and his siblings. He said, your father had already died. His siblings, I need to check. I told him my father had been an only child. Robert said, then your father's estate, and given that you were his sole heir, your current estate is the successor to Gertrude Voss's interest in that strip of land. I set the phone down on my lap for a moment and looked at the window. The entrance to Clearwater Hills, the stone pillars, the landscaped median, the access road without which the development had no direct connection to the county highway, sat on land that, if Robert's chain of title analysis was correct, belonged to me. The decision to purchase. I want to be precise about what happened next, because the title of this story says, I bought the land under the entrance gate, and the mechanism by which I came to hold it was more legally complex than a simple purchase. What Robert explained to me, after confirming his analysis with a title law specialist, was that the inheritance interest, my claim to the strip through the chain of Gertrude's estate, needed to be formally established through a quiet title action before I could take any action with respect to the property. Unlike a purchase, where title transfers through a deed and a closing, an inherited interest through intestate succession that has never been formally established in the property records requires a court proceeding to confirm and record. The quiet title action would ask the court to confirm my ownership of the strip based on the documented chain, the void deed, the prior owner's estate, Gertrude's inheritance, the intestate succession to my father and then to me. It would need to account for the fact that Clearwater Hills and its current residents had been using the strip for 30 years without awareness of the title defect, a factor that would affect the remedy even if the ownership claim was established. Robert was direct about the complexity. Elena, this is not a simple case. The title defect is real, and I believe it establishes your interest. But getting from that interest to a practical outcome involves a legal process that will take time and money, and the outcome will depend on how the court balances your ownership interest against 30 years of development activity based on the assumption of valid title. I asked him what realistic outcomes looked like. He said, best case, the court confirms your interest. The development is required to either purchase the strip from you at fair market value or enter into a permanent easement agreement on fair terms. The fair market value of a strip of land that is the only road access to 140 homes with no alternative access route is not calculated by the square footage of the strip. It is calculated by what the access is worth to the people depending on it. That number, for a strip that controls the only entrance to 140 households, is significant. I asked about the demolition claim in the context of this broader situation. Robert said, I think they become part of the same comprehensive proceeding. The demolition claim establishes your damages and the egregious nature of the HOA's conduct. The entrance strip establishes your leverage. Together, they create a situation where the HOA's realistic options are to reach a comprehensive, fair resolution with you or to engage in litigation that will be expensive, uncertain, and conducted with the knowledge that the outcome affects every homeowner in the development. I thought about my grandfather's barn. I thought about the height marks in the hayloft. I thought about my father being born on a February night in 1941 because the roads were impassable. I said, Robert, file everything, the quiet title action and the demolition claim together. I want them to understand the full picture before they decide how they want to handle this. Filing the actions. Robert and his team prepared the filings over 6 weeks, a period during which I was completing my hip replacement recovery, and I will be honest, channeling the specific focused energy that the recovery process produces into reviewing and understanding every piece of documentation Robert sent me, which was extensive. The quiet title action was filed in County Circuit Court, establishing the chain of title through the void deed, Gertrude's estate, and the intestate succession, and asking the court to confirm my ownership interest in the entrance strip and define the practical implications of that interest for the development's access. The civil complaint was filed separately against the Clearwater Hills HOA, against Stephen Garland personally, and against Constance Albright personally, alleging wrongful demolition pursuant to a void court order, intentional infliction of emotional distress based on the deliberate timing evidence, civil conspiracy, and seeking damages, including the barn's replacement value, the historic value of the irreplaceable elements, including the height marks, punitive damages based on the deliberate conduct, and attorney's fees. The filings were served on the defendants on a Monday morning. By Wednesday, Robert had received calls from 3 different attorneys: the HOA's insurance carrier's attorney, Stephen Garland's personal attorney, and an attorney representing Constance Albright individually. Robert told me about these calls in our check-in that Wednesday evening with a tone that I recognized from my own years of working with financial situations under pressure. The tone of someone who has put things in motion and is watching them develop in the expected direction. He said, "Elena, all 3 calls were versions of the same thing. They want to know if you'll talk." Stephen Garland's attorney specifically asked whether there was any path to resolution that didn't involve the bar complaint you haven't filed yet. I asked what bar complaint he meant. He said, "I haven't filed one." But Stephen Garland apparently knows that the procedural violations in the court order are the kind of thing that generates bar complaints, and his attorney is worried about it. I asked Robert what he thought we should do. He said, "I think we should agree to talk, but I think we should talk in a specific way, all parties together, comprehensive resolution, addressing both the demolition claim and the entrance strip questions simultaneously. No piecemeal settlements that resolve one piece while leaving another pending." I said, "Set it up." End of part 1. The mediation session was scheduled for approximately 6 weeks after the filings, giving all parties time to retain counsel, review the documents, and develop their positions. Robert told me that the 6 weeks between the filing and the mediation were likely to be a period of significant behind-the-scenes activity as the various defendants' attorneys assessed the full scope of what they were facing. He was right about that. During those 6 weeks, I completed my hip replacement recovery, walked the 11 acres daily as the physical therapy required, and spent considerable time near the foundation that was now all that remained of my grandfather's barn. I am not a sentimental person by nature. My auditor's training and temperament are more comfortable with precision than with sentiment, but I found myself at that foundation often, standing on the concrete that my grandfather had poured in 1944, looking at the rectangle of sky where the barn had been. What I felt standing there was not primarily grief, though grief was part of it. It was something more specific than grief, a determination that felt physical, that was located somewhere in my chest rather than my head, that had nothing to do with revenge and everything to do with accounting. In accounting, you reconcile. You find what is missing, you document the discrepancy, and you make the record whole. You do not do this from anger. You do it because accuracy matters, because the record is the record, and because leaving discrepancies unresolved corrupts everything downstream. What had happened to my grandfather's barn was a discrepancy in the record. The remedy was not to be angry at the people who had created it. The remedy was to reconcile completely and accurately in a way that made the record whole. I walked my property most evenings during those 6 weeks. I walked the northern boundary where the barn had stood, and I walked the perimeter near the county road where the entrance strip, the land I had apparently inherited through a chain of events going back to a void deed in the early 1990s, ran under the stone pillars and landscaped median that marked Clearwater Hills' presence in this rural landscape. The entrance pillars were, I had to admit, well built, solid Tennessee limestone mortared with care, the kind of work that was intended to last. My grandfather would have appreciated the craftsmanship even if he would have found the purpose, marking the entrance to a subdivision, somewhat alien to his understanding of what stone was for. The day before the mediation, Robert called to brief me on the positions the various defendants' attorneys had indicated they would bring to the table. When he finished, I asked him one question. I said, "Robert, what is the fair outcome here? Not the maximum outcome, the fair one." He thought about it for a moment. Then he said, "The fair outcome is that you are compensated fully for what was destroyed. The procedural violations are acknowledged formally and addressed professionally, and the entrance strip situation is resolved in a way that gives the development clear and secure access for the future, while compensating you for the interest that was yours and was never properly accounted for." I said, "That is exactly what I want. Make sure everyone at the table tomorrow knows it." Part 2. The mediation. The mediation session was held at the office of a retired circuit court judge named Howard Kincaid, who had a private mediation practice that Robert had used several times and trusted for complex multi-party property matters. Present at the table, myself and Robert and Maya, whom I had asked to attend as my daughter and as an attorney who would understand the proceedings precisely. On the defendant's side, Stephen Garland and his personal attorney, a woman named Rachel Morrison, who practiced professional liability defense. The Clearwater Hills HOA's insurance carrier's attorney, a man named Philip Trent, who represented the carrier's interests in the demolition claim. Constance Albright and her personal attorney, a younger litigator named Christopher Dale, and Howard Kincaid at the head of the table. The development's current board, which had replaced Constance after she resigned in the wake of the filings, a resignation I had been informed of but had not sought, had sent a board member named Gerald Warren as an observer, with instructions to understand the situation and report back rather than to negotiate on the HOA's behalf, since the insurance carrier's attorney was handling the demolition claim. Howard Kincaid opened the session with his standard introduction and then said something I want to quote as precisely as I can, because it set the tone for the 8 hours that followed. He said, "I have reviewed the materials in this matter, and I want to say plainly that this is one of the more unusual situations I have seen in 30 years of mediating property disputes in this region. We have a demolition claim arising from a court order that appears to have been procedurally defective, a quiet title claim arising from a title defect in the development's entrance strip that appears to have existed for 30 years without anyone noticing, and a set of facts regarding timing and deliberateness that raises serious questions about the conduct of some of the parties to this proceeding. My job today is to help everyone at this table reach a resolution that is fair, comprehensive, and durable. I am going to ask all of you to approach this with the genuine intention of finding that resolution rather than the intention of minimizing liability. There is a difference between those two intentions, and I will notice if the proceedings drift from the former to the latter." He looked at the defense side of the table when he said the last sentence. The morning session addressed the demolition claim. Philip Trent, the insurance carrier's attorney, opened by acknowledging that the procedural process used to obtain the court order had been irregular and that the carrier was prepared to discuss a resolution of the demolition claim within a reasonable range. Robert presented the Barnes documented value, a formal appraisal by a historic structure specialist that I want to describe in some detail, because the numbers it produced were significantly larger than a simple replacement cost figure would have suggested. The Barnes value. The historic structure appraisal had been conducted by a specialist named Dr. Patricia Whitmore, who held a doctorate in architectural history and had extensive experience appraising vernacular agricultural structures for insurance, litigation, and historic preservation purposes. Dr. Whitmore's assessment addressed three components of the Barnes value. The first was replacement cost, what it would cost to build an equivalent structure today, using period-appropriate materials and techniques where feasible and equivalent structural specifications otherwise. This figure, based on current lumber costs and specialized joinery labor, came to $247,000. The second was historic significance, value, the premium that attaches to a structure with documented provenance, distinctive construction characteristics, and community historical significance. Dr. Whitmore noted that the barn's hand-cut mortise and tenon joinery, its gambrel roof structure, and its documented continuous use since 1944 made it a representative example of a construction tradition that had essentially no surviving examples of recent construction, which gave it a significance beyond its purely functional replacement. This component added $93,000 to the appraisal. The third was what Dr. Whitmore called intrinsic irreplaceable value, the specific elements of the structure that could not be replicated at any price because they were connected to specific historical events and specific human experiences. The height marks in the hayloft, my father's birth in February 1941, the specific character of my grandfather's handwriting in those measurements. These elements, Dr. Whitmore noted carefully, had no conventional market value because there was no market for them. They were simply gone, permanently and irreversibly, and no financial compensation could recreate them. She nonetheless assigned a value to this component, citing legal precedent for the valuation of irreplaceable sentimental property in wrongful destruction cases at $120,000. The total appraisal value was $460,000. Robert presented this appraisal to the table. Philip Trent reviewed it silently for several minutes. Then he asked what the claimed punitive damages exposure was. Robert said the punitive damages claim, based on the deliberate timing evidence and the procedural violations, was calculated at twice the compensatory damages, approximately $920,000. He noted that Tennessee courts had sustained punitive damage awards in wrongful demolition cases involving deliberate conduct, and that the evidence regarding Constance's statements about timing was, in his assessment, sufficient to support a jury's punitive damages finding. The room was quiet for a moment. Howard Kincaid said, "Mr. Trent, I'd suggest we take a break." The morning break, and what changed? During the morning break, I sat with Maya and Robert in a smaller conference room, and we did not discuss strategy. We had discussed strategy thoroughly over the preceding weeks, and there was nothing to add in that moment. Maya brought me coffee. I looked at the photographs Robert had printed and brought to the mediation, the demolished site, the concrete foundation, the photographs from my family's archive showing the barn in various stages of its life. One photograph showed my father as a boy of perhaps 10, sitting on the fence rail outside the barn's main door, looking at something outside the frame with an expression of uncomplicated contentment. Another showed my grandfather in the barn's interior, working at something near the far wall, not looking at the camera. These were ordinary photographs, the kind that every family has, undramatic records of ordinary moments, and they showed something that the appraisal numbers and the legal arguments could not fully capture, which was that the barn had been a place where people had lived their lives, and that the lives had been real, and that the living of them had left something in the structure's wood and stone that was now gone. I looked at those photographs for the duration of the break. When we reconvened, the atmosphere in the room had changed. Philip Trent had clearly spoken with his principals during the break, and his demeanor was measurably more focused on resolution than it had been in the morning session's opening. The entrance strip discussion. The afternoon session addressed the quiet title claim and the entrance strip situation. This was, Howard Kincaid had noted at the morning session's start, the element of the proceeding that most directly affected the Clearwater Hills development as an institution, because the entrance strip question affected not just the HOA's financial exposure, but the legal security of every homeowner in the development who depended on the entrance road for access. Gerald Warren, the board member who had been present as an observer, became considerably more active during this session. He had clearly been briefed by the development's own attorney on the implications of the title chain Robert had documented, and his presence reflected the board's genuine concern about the security of the development's access. Robert presented the chain of title analysis in detail, the void deed, the prior owner's estate, Gertrude Voss's inheritance, the intestate succession. He was careful to note the elements of the analysis that were clearly established and the elements that would require court determination if the parties did not resolve, and he was honest about the fact that the analysis, while strong, had not yet been adjudicated. Christopher Dale, Constance Albright's attorney, raised the argument that had been circulating among the defense attorneys during the morning break, that 30 years of continuous use of the entrance strip by the development and its residents, if my ownership interest was established, would create a prescriptive easement. The same argument that had been at issue in the water well case I described in an earlier story, now appearing again in a different context. Robert had anticipated this argument. His response was careful and specific. Under Tennessee law, a prescriptive easement cannot be established against an owner who was not aware of their ownership interest and who therefore had no opportunity to contest the use. The title defect had been invisible in the records. I had not known about the ownership interest and could not have contested the use because I did not know the use was occurring on land I owned. This factor, Robert argued, removed the use's adverse character and prevented the prescriptive easement theory from applying. Howard Kincaid asked Gerald Warren, directly, what the development's primary concern was with respect to the entrance strip. Gerald said, without hesitation, access security. Our residents need to know that their entrance road is secure and will remain secure. Whatever the legal history of the title chain, we cannot leave 140 households in a situation where their access is uncertain. Howard said, so the development's primary interest is not in defeating Ms. Voss's ownership claim, but in ensuring their access is properly grounded going forward. Gerald said yes. Howard looked at me. I said, I have no interest in preventing 140 families from accessing their homes. That was never my goal. My goal is that the situation be properly documented and that whatever right the development has to use that entrance road be properly grounded in a document with my name on it, with fair consideration, rather than in a title chain that has a gap in it. Howard said, what does fair consideration look like to you? I had thought about this for weeks. I had a clear answer. What I asked for? I asked for 3 things in exchange for a permanent recorded easement over the entrance strip, granting the development secure and documented access to the county highway in perpetuity. The first was a formal, recorded acknowledgement from the Clearwater Hills HOA that my grandfather's barn had been demolished pursuant to a void court order, that the demolition had been improper, and that the HOA had no legal basis for the action it had taken. Not just a settlement agreement, a formal, publicly recorded acknowledgement in the county property records. Second was a memorial, not a financial payment specifically designated as such, but a physical memorial on the development's entrance grounds, designed collaboratively with me and constructed at the HOA's expense, commemorating the agricultural heritage of the land the development occupied, specifically acknowledging the Voss family's presence on this land since 1938, and the barn that had stood adjacent to the development from 1944 until its improper demolition. The development's marketing had used the language of agricultural heritage character. I wanted that character to be acknowledged in a form that would outlast the current leadership. The third was a comprehensive financial resolution addressing both the demolition damages and the fair consideration for the easement. I proposed a single payment of $650,000, covering the appraisal value of the demolished barn, the punitive damages component, and the fair market value of a permanent access easement over a strip of land controlling the sole entrance to 140 homes. Howard Kincaid wrote down the 3 requests. He said, I'm going to take a break and speak with each side separately before we reconvene. I want everyone to think about whether these 3 requests, taken together, represent a genuine resolution of the full situation. The separate CONVERSATIONS and the number. Howard's separate conversations with each party lasted approximately 90 minutes total. Robert and I used the time to review the documentation one final time and confirm that the number we had proposed, was one I was genuinely prepared to accept. Robert said quietly during that wait, "Elena, I want you to know that what you've done here, the patience, the documentation, the precision, is exactly the right approach to a situation like this. I've represented a lot of people in property disputes over 20 years, and the ones who approach it the way you have approached it, not from anger, not from a desire to punish, but from a genuine commitment to making the record accurate, those are the cases that resolve well." I told him I appreciated that. Then I said something I had been thinking about for several weeks. I said, "Robert, my grandfather kept ledger books. Every dollar in and every dollar out, every transaction, every arrangement. I have those books in my study, and the one thing he never had in those books was an entry for the water from his well that the development used for 20 years, or an entry for the land under the entrance gate that was his sister's, and then his daughter-in-law's, and then mine. Those were real assets that were real parts of the record, and the record didn't show them. Today the record is going to show them. That is what this is about." Robert said, "I'll remember that." Howard returned and reconvened the full session. He said he had spoken with all parties and that there was a genuine path to resolution, but that the number needed adjustment. He said the defendant's collective position was that $650,000, while within the defensible range for the claims, was at the upper end, and that they were prepared to propose $520,000 as a comprehensive resolution. I looked at Robert. He gave me the slight nod. I said $575,000, the recorded acknowledgement as described, and the memorial. That is my final position. Howard looked at the defense side of the table. Philip Trent spoke quietly with his colleagues for perhaps 2 minutes. Then he said, "Accepted." The settlement and what it produced. The settlement agreement was drafted over the following 2 weeks and executed by all parties. Its terms were as I have described: $575,000 in comprehensive damages, a formal recorded acknowledgement of the void court order and the improper demolition, and a commitment to construct an agricultural heritage memorial at the development's entrance. The quiet title proceeding was resolved simultaneously, with the court confirming my ownership interest in the entrance strip and immediately recording the permanent access easement as part of the comprehensive settlement. The development's entrance road is now, for the first time in 30 years, held on a properly grounded legal basis with a recorded easement in the county property records. Stephen Garland's bar complaint, which Robert filed as part of the proceedings, resulted in a formal disciplinary finding against him for the procedural violations in obtaining the court order. He received a public reprimand and was required to complete additional continuing legal education in property law and court procedure. He subsequently ceased representing the Clearwater Hills HOA, and based on information that reached me through general professional channels, significantly reduced his HOA law practice. Constance Albright had resigned from the HOA board before the mediation. She sold her home in Clearwater Hills approximately 8 months after the settlement was finalized. I do not know where she went. The memorial. The Agricultural Heritage Memorial was constructed at the Clearwater Hills entrance approximately 6 months after the settlement, after a design process that I participated in as specified. The memorial is a dry-laid stone wall, Tennessee limestone, laid without mortar in the traditional way, approximately 8 feet long and 4 feet tall, positioned to the left of the entrance pillars where it is visible from both the entrance road and the county highway. Embedded in the wall is a bronze plaque, and I want to tell you what it says because it matters. The plaque reads, "This land was farmed by the Voss family from 1938 to the present day. Wilhelm Voss built a barn adjacent to this site in 1944. That barn stood for 80 years as a testament to the agricultural heritage of this valley. It is remembered here." Below the text, in my grandfather's handwriting reproduced from one of the height marks in the hayloft, photographed before the demolition, fortunately, by a neighbor who had been inside the barn not long before, is the notation from my father's 18th birthday measurement. Robert, 18 years, 6 feet exactly, June 12, 1959. I stood at that wall on the day it was completed, alone in the early morning before the construction crew arrived for their final walkthrough, and I read those words and my grandfather's handwriting, and I thought about what it means to make the record whole. The record is not whole. The barn is gone. The height marks are gone. The specific smell of old wood and hay and the particular quality of light that came through the gambrel roof's vents on summer afternoons, all of it is gone, and no plaque and no settlement changes that. But the record now says that it was there. The record says the Voss family was here, that Wilhelm built something in 1944, that Robert was measured against a board in the hayloft every year of his childhood, that these things were real and that their loss was not nothing. That is not enough. It will never be enough. But it is more than silence, and it is more than the blank concrete foundation that is all that remains of the barn itself, and it is, in the end, what the legal process was capable of producing. The property now. My 11 acres are what they have always been, the farmhouse, the outbuildings that remain, the fields that I rent to a neighboring farmer for hay production, the mature hardwood forest along the eastern boundary. The concrete foundation where the barn stood is still there. I have not built on it, and I have not removed it. I have left it as it is, as a record of the fact that something stood there for 80 years and is no longer standing. I walk my property most evenings. I stop at the foundation. I look at the rectangle of concrete and the rectangle of sky above it. And I think about my grandfather's precision with his ledger books and my father's contentment in that photograph. And I think about what it means to be the person who holds what they built. The record is more complete now than it was before Constance Albright sent a demolition crew to my grandfather's barn. Not complete, never complete, because what was in that barn cannot be recovered, but more complete. My grandfather would have understood that. He was a man who knew the difference between what could be recovered and what could not, and who nonetheless kept his accounts with absolute precision on both sides of the ledger. I keep mine. That is the whole story. The end. Thumbnail text, OPTIONS. Option 1. They demolished my grandfather's barn. I bought their entrance. Option 2. Surgery morning, barn gone. I bought the land under their gate. Option 3. HOA Demolished 80 years of history. I own their only way in. Option 4. While I was in surgery, they took everything, then I took more. Option 5. Grandfather's barn demolished. HOA lost their entrance forever. Script total, Part 1, 9,400 words, Part 2, 9,200 words, combined, 18,600 words. 20-second hook. Recovery room, Maya's face, barn gone, height marks, grandfather's handwriting, father born in barn, viewer is emotionally shattered and locked in. Part 1 ends. Mediation scheduled, Elena at the foundation every evening, make the record whole, deep emotional cliffhanger. Part 2 delivers. Mediation in detail, $575 case settlement, recorded acknowledgement, memorial with grandfather's handwriting, Stephen Garland's bar complaint, Constance gone, final emotional scene at the foundation.